already. Thank you very much. My name is Zugwai I'm a Program Manager Elections with ElectHER, and I will be your host for today. Thank you once again for joining us. We will kick off our conversation with a quick housekeeping rules and introductions. Thank you for registering. Thank you for being a part of the conversation. And today we would be having our Decide to Run series 1. This is our inaugural series, and its focus is on understanding the Electoral Act 2026 as candidates and aspirants for the 2027 elections. We believe that is very key for us to understand the legal framework that governs our activities as aspirants and candidates in terms of our responsibilities and also expectations and requirements through the process, which is why we have created this platform to be able to support the journey and support our candidates and aspirants, especially the female candidates. This session is a candidate support session for female candidates and aspirants. So thank you once again for joining in. A few housekeeping rules and things to look forward to. We will be having a conversation for about 40 minutes. However, in the course of that conversation, please, if you have questions, comments, and feedback, you can leave that in the chat section, or you can just write it down so that at the end of the session, you will be allowed to respond to ask your questions either verbally or we will respond through the chat box. Right now, I will be welcoming our CEO, the Chief Executive Officer of ElectHER, in the person of Ibijoke Faborode, to give us her welcome address. Thank you so much. Ibijoke, you have the floor.
Thank you very much, Zugoi. Can you hear me?
Yes, clearly.
Okay, I think I'm working between two systems, so I'm trying to get my video off. Let's see if I can do better with this. You'd forgive me, I am joining from two devices at the moment, but good afternoon to everyone. Thank you so much for joining us on this inaugural session. My name is Ibijoke Faborode, as Zugwe introduced me, and I'm very delighted to welcome each one of you to the very first edition of our Decide to Run series today. Now, for us at ElectHER, this moment really matters because just months ago, a new law, which is the Electoral Act 2026, was signed, and it changes the rules for every single person running in 2027. So today, as part of our candidate support initiative, we are making sure that women are not the last to understand what has changed. Over the next few months, the Decide to Run series will walk you through every part of the campaign, from the law we're covering today to building your message, raising resources, safety, taking care of yourself, and getting ready for election day and beyond. Before we close today, we'll share more on what's coming next and when, so you know exactly what to expect and how to plan along, essentially understanding our plans as we support, female candidates that are running to win in the 2027 general elections. This series definitely does not exist in isolation. It sits inside ElectHER broader candidate support work, which we've been building since the 2023 general elections. For those of us that know about, for those of you on the on the call today that know about ElectHER, if not, you get to know more about our work on how we supported both aspirants and candidates in 2023 to mobilize campaign, building their capacities, giving them access to networks and visibilities as well. And through election cycles, through funding landscape that have not always been generous to this work. And and of course, for us, it's a simple refusal to let that shrink our ambition for women in this country. So ahead of 2027 elections, we will be rolling out several initiatives to support female candidates. as such, they decide to run, such as they decide to run brain trusts, which will pair candidates with technical advisors pro bono, documenting and following women's campaign journeys, so their stories are recorded and not lost, and partnering with like-minded organizations to help mobilize resources for candidates wherever that is feasible. So the masterpiece that we are hosting today, being the first edition, is definitely one piece of a much larger commitment from us at ElectHER. Excuse me. So why does this matter much today? Why are we having the first session, helping you understand the Electoral Act 2026? It's simply because knowledge really matters, and knowledge does protect you as a candidate. And it's important for you to know the most important piece of legal instrument governing, guiding, and shaping the 2027 election. So every woman in this race already carries odds that were never stacked in their favors. And one thing that we have within our control, is whether we walk in prepared and informed. And so you must know this landscape well, because you don't get the same room for errors that every other person has as a woman, and we know this. So I know this room holds many kinds of women today. I know some, also invited, some of their campaign staff. Some are running as candidates, and some are still deciding whether to run in the future or simply are here to just understand the law better. So whether you're in the mix, you belong here, and we definitely look forward to going on this journey with you in the next hour and over the next few months as well. So before I hand over, let me say this about the facilitator today. She's one of the sharpest legislative minds working on gender and electoral policy in this country. And you're about to see exactly why. I think when she speaks, she's going to deliver beyond expectations because she knows our onions. So we look forward to delving, into this session with her really soon. And to the Policy and Legal Advocacy Center PLAC, thank you for the partnership and the leadership in making this, collaboration possible, this session possible. And to the European Union that continues to support the inclusive governance space in Nigeria through the EU SDGN program too. You've made the session entirely possible. Thank you very much, for supporting us. And so that we can manage time, because today is definitely a Friday and people are wrapping up their days, it is my honor to then welcome our facilitator for today's session, Miss Nkiru Uzodi, who currently serves as Program Manager, Legislative and Gender Issues at PLAC. Nkiru, thank you so much for joining us. Welcome. I think we need to give Nkiru co-host, otherwise you can just unmute yourself. We look forward to the session with you where you'll be talking us through understanding the Electoral Act 2026. Welcome again. Thank you very much.
Okay. Good evening, everyone. Good evening, Bijake. Thank you so much for that introduction. I don't think I can share my screen, and I don't know, hopefully that is being fixed. But I would like to thank ElectHER, the organizers, for inviting PLAC and myself to contribute to this very important conversation. So our focus today is the Electoral Act, and I've added a subtitle to that: what every woman aspirant, candidate, and campaign team needs to know in order to run, protect her vote or their vote, and defend the mandate. So whether you're a declared candidate, an aspirant who navigated a tough primary, a campaign manager, or a key strategist, this session is engineered to equip you with a concrete, actionable legal blueprint. But I'd like to begin with one important clarification, which is that this will not be a section by section reading of the Act. The Electoral Act is very technical, like we all know. I will take us through the legal journey that a political ambition must travel before it becomes a secure electoral mandate. So we'll cut through complex legalese, examine what the law says, what matters to your campaign, what you must do at every stage, from party registration to defending your mandates. So the central message of this session is that legal literacy is not separate from political strategy. In fact, it is part of political strategy. So I don't know. Okay, yes, I can share my screen now. So I just want to be sure that you can see my presentation. Okay. Please, can I confirm that you can see my presentation? Okay. All right. Yes, so I have a question on the screen. And that question says, what must happen at every stage from party membership to declaration for a woman's candidacy to become a secure electoral mandate? So I am not asking for an immediate answer. I would just simply like us to hold the question as we proceed. We're not asking how do we win an election. So I think the deeper question really is, how do you guarantee that you as a candidate, is not disqualified in court before election day? How do you ensure your votes are not invalidated during collation? And how do you make sure your victory withstands legal scrutiny? So a mandate is not secured because a candidate is popular or runs a strong campaign or receives the highest number of votes. So several legal and administrative things must go well. So first of all, the candidate must have a lawful basis to participate in party process. The primary and nomination of that candidate must comply with the law and party rules. And then her qualification document must also withstand scrutiny. Her campaign must operate within legal boundaries. Then in terms of process, on election day, the votes must be properly accredited, counted, recorded, transmitted, collated, and declared. Then with regards to evidence and time, if a dispute arises, the campaign must use the correct legal pathway and act within time. So that is why the four words on these slides matter: law, process, evidence, and time. So a weakness in any one of them can actually expose an otherwise strong candidacy. So with that framing, let me clearly state what participants should take away from this session. One, identify major reforms affecting aspirants, candidates, and campaign teams, understand key legal stages and deadlines in the electoral cycle, recognize major pre-election, campaign, and election day legal risks, understand the results management process, appreciate the importance of early legal preparation and evidence gathering. So the easiest way to understand the Electoral Act, without going into the technical legal details, is to understand the Act from a candidate's perspective. That is to see it as a journey, and that's the way this presentation is framed. So this slide gives us the map for the entire session. So the journey starts with an aspirant or someone who wants to run being a member of a political party, because that's what the Constitution requires. So the journey starts with the membership register. It then moves to primary election, nomination, qualification, scrutiny, the campaign, voting, results management, declaration, and where necessary, review or litigation. Then these stages are connected. A problem, for instance, a problem in the membership register can affect who is entitled to vote or be voted for in a primary. If the primary is flawed, it can become a pre-election case. If there's a mistake in your nomination documents, it can lead to disqualification. If you have a poorly trained polling agent and that agent is unable to obtain results from evidence, from the elections that a legal team will need later, that will be a problem. So a discrepancy that is not raised during the voting or collation process can become much harder to explain after declaration. So essentially what I'm saying is that if any link in this legal chain breaks, your candidacy is actually vulnerable. So at this stage, we'll ask 3 questions. What does the law say? Why does it matter? And what should the campaigns do? So before we examine the stages individually, let us look at 6 broad shifts that shaped the new electoral framework. So we're all aware that this new electoral act was passed recently, this year in February. And before then, we had an electoral act that was passed in 2022. So this is an entirely new legal framework, even though some of the provisions from the old act were retained. So, but for the purpose of our audience and today's presentation, I've identified 6 major shifts. The first is the electoral calendar or the electoral clock. So we have revised statutory timelines and INEC's operational timetable. We are all aware that, traditionally elections in Nigeria happen around February, March, or even into April for state level elections. With INEC's new calendar, that has shifted. If we've been following the conversation, I think we'll know that a lot of the INEC timetable has been front-loaded. But, to be more specific, so the time for nomination now closes 120 days before election day instead of 180. And some of the relevant sections include sections 3, 9, 18, 29, 77. If you look at my slides, I put the relevant sections at the top right-hand corner, so that it's not distracting, or that we're not distracted from the core message. Then the second is the party membership register. It has become much more consequential. It is now a very strong identity-based record. Usually, there was no requirements for party register to contain, photos, name, and the rest of it. So all those requirements are now introduced into the Electoral Act. And now, in fact, it has become more consequential, because if there are defects in the party register, if your name is on the party register, then there are consequences. You will not be able to vote or be voted for during party processes. Then, of course, the third concerns the primaries method, nomination, and qualification. Prior to 2026, there were three methods. We had direct primaries, consensus, and indirect primaries. Direct primaries have now been removed from the law, and qualification disputes have become even more relevant in the pre-election period. We'll get to that later. Then fourth, campaign finance. So the Act revises spending ceilings, donation rules, and reporting obligations. Although we must discuss this alongside the reality of weak enforcement and the gender cost of politics. Then the fifth is results management. The Act now more clearly connects beavers accreditation, the polling unit results, electronic transmission, which I think is the most popular, or should I say the most significant change in the Electoral Act, at least from citizens' perspective. And also there are provisions on statutory verification during collation. So the sixth is dispute resolution. INEC's power to review declarations under Section 65 is now narrower and more specific. We'll get to that. And then the statutory grounds for election petitions have now been reduced. It used to be 3, but there are only 2 grounds. We'll come to that later. So the practical message is simple. Fewer things can safely be left until after election day. So the first discipline for any serious campaign is knowing the clock. In electoral matters, knowing that you have a right is not enough, but you must know when that right must be exercised. So there are 3 different clocks to track. One is the constitutional timelines set in stone by the Constitution. For instance, the time for fixing elections is a constitutional matter. The Constitution empowers INEC to set timelines for election, and it is based on that mandate that INEC goes on to set out their calendar. And even within that power, there are still statutory timelines within the Electoral Act. So for instance, another example of a constitutional timeline is the mandatory 14-day window to file pre-election matter. So the Constitution says that once you have a pre-election complaint, you have 14 days from the day the cause of action arose to file a pre-election suit. If not, you'll be locked out. Then for election petitions, you have 21 days from the date of declaration of results, and then there's a 180-day time limit for judgment. Then within that constitutional timeline, the Electoral Act now derives its force to set out deadlines. So those are statutory windows, for instance, sections 28 to 32, regarding, for instance, INEC release of funds, submission of candidates' particulars, publication of candidate particulars, campaign duration, all that's Electoral Act deadlines. Then we now have the INEC administrative calendar. So those are mostly operational schedules in the official timetable. For instance, deadlines for voter registration. Even though the Act has a cutoff date, so INEC is still empowered within those timelines to set out a time to register voters and close the registration process. Same thing with deadlines for agent submission. So litigation has its own severe deadlines. I already mentioned the timelines for pre-election matter and election petition. So the actionable advice here is that a campaign needs one integrated calendar that tracks all 3. So the practical action for candidates, aspirants, and campaign managers is to appoint one person to maintain your campaign's legal calendar, paying attention to the provisions. The sections are on the slides. I already mentioned that. So these are not ordinary civil cases where a person can wait and negotiate for months and then decide to sue. That's not going to work. So the next stage is one that many aspirants previously treated as a party formality, but Section 77 makes it a serious legal response. So Section 77 now is party member registers. I already mentioned that the register is no longer a simple handwritten list kept in a ward office. It is now structured, these are the requirements, for a party register: namesake, date of birth, address, states, local government area, the ward, the polling units, national identification number, photograph. And this is actually compulsory. There are no exceptions to having these items or this information captured in a party register. So for aspirants, I think the lesson is to learn to verify membership status early and preserve proof. So for their legal questions that can arise, on this particular issue, was a candidate's name in the register that was submitted? What register was used for the primaries? Was that register submitted on time? Because there's a timeline, a cutoff time for submitting party register. Was that same register used for the primary? And there were the people who voted at that primary, were they lawfully entitled to participate? And were they altered or competing versions? In fact, the whole purpose of this section was to cure this problem of duplicate registers within parties where, different registers are floating around. Nobody really knows which one is the authentic register. So these are questions to ask. And, Section 77 is a key provision of the Act to pay attention to. So for campaign teams, the lesson is to treat register issues as potential evidence issues, not as matters to investigate only after the primaries. So once we know who is legally entitled to participate, the next question to ask is how the party chooses its candidates. So moving on to primaries, party rules, and internal democracy, again, provisions of the Act are indicated on the slide. So the relevant sections are sections 82 through 88. They are very comprehensive and very detailed. They govern internal party democracy. So under the 2026 framework, like I mentioned, indirect primaries have been removed, so there's no more delegate system, leaving direct primaries and consensus as the legal pathways. And it doesn't necessarily mean that direct primaries are automatically fair, because that was one of the reasons given for removal of indirect primaries, the corruption in the system. So the credibility of this system depends on the membership register, party guidelines, the venue and process, the officials conducting the exercise, the recording of votes, and INEX monitoring. And what the 2026 framework does that the 2022 framework did not do was to put considerable weight on party constitutions guidelines. So that means that an aspirant must obtain and read the party constitution. You have to know the provisions, the primary guidelines, notice, list of eligible participants, result sheets, and relevant correspondence. So these documents can actually become the operating rules against which the process is judged, because under the law, there is no standard, should I say, procedure now for electing for nominating candidates, because it's now left to parties to design. So when candidates or aspirants go to court, the courts are going to be looking at the party constitution. So that's a very critical document. And then for consensus, there are also legal conditions. The Act doesn't just say, oh, you can do consensus. There are rules attached to consensus. Aspirants must be identified. There has to be written consent. And of course, we know with that comes the risk of duress and coercion or pressure. The candidate must be properly ratified. And if the consensus fails, the party should revert to the legally prescribed alternative. INEC monitoring is also important, but the presence of INEC officials does not automatically cure every defect or guarantee that the process complied with the law. So I will say that for an unsuccessful woman aspirant, speed is critical. If she was unlawfully excluded, if the wrong register was used, if notice was defective, or if the consensus was imposed without the required consent, the complaint may be a pre-election matter with a very short filing window. I already mentioned that there's a 14-day timeline for filing pre-election matters. So emerging from the primary is a major political victory for a lot of politicians, but it's not the same thing as a valid legal nomination. So those are two different things. So to the next slide. So winning your party primary is a major milestone, but converting that into victory, into an airtight nomination, requires meticulous administrative diligence under sections 29, 31, and 32 of the Electoral Act. So after the primaries, the candidates and campaign must confirm that the correct names and particulars were submitted to INEC, because that can become a litigated issue, can become a contentious issue. And do not assume that because the party announced a winner, every document was accurately completed. It's important to check, name spellings, order of names, voter card certificates, affidavits, dates of birth, educational details and declarations. I have seen several petitions where this became big issues. And it's also important to monitor the publication of candidate particulars so that any error objection is identified quickly. That most of these processes, outlined in INEC's calendar. So, but I think it's very key to also know that candidate substitution under our law is strictly prohibited, except in cases of voluntary withdrawal. And that withdrawal has to be accompanied by an affidavit. And the second other case is in cases of death. So it's very important for a candidate and a campaign team to actually take note of that important rule and track any attempted withdrawal of substitution and, try to ascertain whether it followed the proper procedure. For an unsuccessful aspirant, this stage matters. The publication of particulars and candidate lists may reveal information relevant to a lawful challenge. I've talked about mistakes, being potentially contentious or false information. But again, there is also the time limits which are prescribed in the Electoral Act, like I mentioned in my previous slide. So the central point is that the party's internal declaration of victory must be translated into a complete, accurate, and legally defensible nomination. So the next slide is more of like a warning, or caution. Even a properly conducted primary does not cure a qualification problem. And I'll have to say that candidate qualification is one of the most contentious and litigated issues in elections. Every cycle, qualified aspirants emerge from primaries, they are very happy, they start their campaigns, they spend money, they contest the elections, and then the next thing, they see themselves thrown out by a court order, mostly due to discrepancies in their credentials. So the risk may arise from constitutional qualification or disqualification requirements, and these include age. That's in the Constitution. You have to be a certain age. You must be a Nigerian citizen. You must not be have been convicted of an offense involving dishonesty. You must not be a declared bankrupt. You must be a person of sound mind. And then you must be a member of a political party. If you're in public office, you must have, resigned at a particular time before the elections. So these are all qualification issues. So it's important that a campaign team examines names, identity documents, age, date of birth, educational qualifications, citizenship or allegiance issues. I have seen cases where a candidate's win was almost upturned because it was found that the person had had sworn allegiance or had citizenship issues. I mean, this may seem very minor, but they are actually very potentially, should I say, issues that can be litigated in court. And again, I had mentioned failure to resign from public office within the constitutionally required period prior to the primary. So I think the action point here is that a candidate should carry out a qualification audit before submission. The primaries are over already. I guess, this will be for the next cycle. And I think this qualification issue is particularly very important, not just because it's highly contentious, but also because the Electoral Act has made a very significant change in how qualification deals with the question. So it is no longer a separate ground for election petitions. Before 2026, in 2022, and in preceding or previous election cycles, you could challenge a candidate's qualification in court post-election at the election tribunal. But in the new Electoral Act, that is not possible anymore because they have deleted qualification as a ground for questioning an election. So what the Electoral Act 2026 has done is to move pre-election challenge and qualification challenges into the pre-election phase. And not only that, in fact, it has even changed the standing in terms of the person who can sue. Previously, members of the opposition or a candidate from the opposition could question a candidate's qualification. Based on the Electoral Act we have now, that can't happen anymore. Only aspirants who contested primaries with another aspirant can question that qualification. So it's more of an internal party matter. I have my personal opinions for this change. I don't think it's a constitutional change. And really looking for it to be interesting to see how the courts interpret this change. But basically, the emphasis here is that do not assume that if you discovered qualification defects in a candidate, that you can defer it to a post-election tribunal. No, it has to be fixed in the pre-election period, unless the law changes or the courts rule otherwise. So once nominational qualifications are secure, the legal risk now shifts to how the campaign itself conducts its activities. And that takes us to campaign of lawful messaging, mobilization, and security. So sections 95 to 101 of the Electoral Act sets clear rules for campaign conduct. So campaigns must be driven by policy issues, not divisive tactics, inflammatory or religious rhetoric. So the law explicitly provides campaigning in places of worship or public educational institutions, using abusive, defamatory, ethnic, or religiously divisive language, engaging private security squads, thugs, or weapons. And then, of course, there's the 24-hour campaign blackout window. So 24 hours to election day, you must stop campaigning, and that includes putting out posters, calling people, appearing on TV, and all that. Doing that, I mean, the electoral offense to actually this provision. And I think, it's very important to note that women candidates often face targeted smear campaigns and venue denials during campaigns. So it's important to remember Section 95, which guarantees equal access to public facilities for all registered parties. But it's also important to note that enforcement of campaign conduct rules have been weak and uneven because these some of them are electoral offenses, but weak enforcement is not a permission to ignore the law. So apart from paying attention to campaign conduct, and if you look at my slides, these rules don't apply only to candidates. They also apply to your campaign staff, your supporters, your spokespersons, and campaign team. There's also the need for financial discipline. Even in a political environment like Nigeria, where enforcement of electoral offenses and campaign finance rules are weak, it's still important that we know these provisions and we try to exercise some form of fiscal discipline. So moving to campaign finance, limits, donations, and reporting obligations. So these provisions, you can find them in sections 91 to 94 of the Electoral Act. These provisions establish statutory spending ceiling, donation limits, and financial reporting mandates for political parties. They are quite exhaustive. Speaking candidly about the Nigerian context, formal enforcement by regulatory bodies have been weak. It's INEC's duty to actually enforce this, but I think this is one of the weakest. That's the weakest thing. So one area where the commission somehow is not able to assert itself or assert its powers. But in spite of that, I think it's important to understand what the law says. So with respect to ceilings, the Act sets spending ceilings for different offices and regulates donations and reporting. So in 2022, we had different donation limits. In 2026, they have increased. So for the Office of Governor, I think it's 3 billion naira. That's the campaign ceiling. Senate, 500 million. House of Reps is 250. And then State House of Assembly is 100 million naira. Same with area council chairperson, then 10 million naira for councillor. For donation cap, the donation ceiling to a single candidate, the single donor cap to a candidate is 500 million naira. So in terms of the expectations, and what the acts, the intent behind these provisions. The intent is that campaigns should track both monetary and in-kind supports, For instance, vehicle, venue, advertising service, promotional materials, printing, accommodation, professional services applied to a campaign. And typically, basic records should include receipts, bank transfers, pledges, donor details, and significant in-kind support. So candidates should also understand the party reporting and audit obligations. The candidates have their own obligations, and the party itself has its own reporting and audit obligations with INEC. So, so the point basically here is that the records can help a campaign monitor legal limits, answer audit questions, demonstrate transparency, and avoid dependence on funding arrangements that may later create political or legal problems. So we now move from the campaign period to the election day and the process that converts votes into results. So if you look at my slide, I have outlined the process that we typically see on election day, and the relevant provisions governing this process is on the slide. So a declared result is produced through a chain of connected legal processes. It begins with accreditation, and what the law says is that accreditation of voters must be done using the biometric voter accreditation system. That's the BVAS machine. And then, you have to present yourself physically with your PVC, even though I hear now that INEC is trying to introduce, is trying to allow, should I say, downloadable PVC. That's more of an operational issue. So from there, we move to voting, and then in the ballot boxes and the counting and recording of the polling units result on Form EC8A. So the Form EC8A is the result form at the polling unit level. And honestly, I would say that this is the foundation of the results, should I say the results management or the results collation process. If anything goes wrong here, it's just going to cascade. It will cascade upwards to the final results. And even in courts, in election petitions, the courts have said that the Form EC8A is the best evidence of what transpired at the polling unit. For them, they want to see these results. For every other thing is not as significant as the Form EC8A. So the polling unit is should be an area of vigilance for candidates and even voters alike. So the result is announced at the polling units and then electronically transmitted. This is a new provision in the 2026 Act. Then it then passes through the prescribed levels of collation depending on the office in question, where the figures are verified and aggregated before the final declaration. So why is this chain important? So because a result may be correctly counted at the polling units and then a wrong figure may be entered and carrying forward a collation. Accreditation figures may not match the votes recorded. Result form may be altered. That happens very frequently. For those that do election observation, you notice that seeing mutilated result sheet is something that's quite common in election. Then under section 47, yes, I've talked about the BVAS. The use of the BVAS is mandatory, and the total number of votes cast at any polling unit cannot exceed the total number of BVAS accredited voters. Then if that happens, according to section 51, the result must be cancelled. So it's very important for candidates and campaigns to train their agents, to train polling agents to understand this results chain. In fact, the polling unit agents are the ones who are responsible for protecting and counting your Form EC8As at the world, local government, states levels. In election, a lot of the cases that I read, the courts didn't just want to see the Form EC8A. They wanted it, they preferred that those result forms be tendered by polling agents. For them, that's the best form of evidence in election petitions. Your polling agents coming forward and tendering the Form EC8A signed or countersigned by him. So a legal team, is important to have a legal team or a situation room to develop a system for receiving and comparing records. So 3 items in this chain are frequently confused. That's EC8A, IRF, and collation. Just to explain it. So the Form EC8A is the physical polling unit result sheet signed by the presiding officer and party agents. It is a primary legal document in election litigation. I cannot stress that enough. Then, of course, the IRF portal, which is a public viewing portal managed by INEC, the Electoral Commission, for viewing transmitted results images. So the aim of the IRF portal is not to declare results or to declare a winner. It's to provide public transparency and verification. So think of IRF as a mirror but it does not replace formal collation. Then, of course, when we talk about collation, we're talking about aggregation of physical results from ward to local government and constituency level. So while electronic transmission is now legally mandatory, there's a net in section 60 of the Electoral Act, there is an exception, a fallback clause, which says that, if network transmission fails, the physical from EC8A remains the primary source of collation. And I think, if we have followed the news and conversation around the Electoral Act, we see that that was a very contentious point when the National Assembly added that exception clause to the provision of electronic transmission of results. So I'll say your polling agents should be able to secure readable signed physical copies of Form EC8A from every single polling unit. A serious campaign should compare three things: the Form EC8A, the transmitted record that is visible electronically, and then the figures carried through collation. Then a mismatch should trigger a red flag and immediate attention. So again, IREV improves public visibility, but it does not announce the legal winner. So again, the takeaway from here is to make the appointment and training of polling agents one of the most important legal readiness decisions a candidate will make in the course of her campaign. Then under section 43(1, now I'm speaking also further about polling agents, the new provision that says that candidates can now appoint agents. In the 2022 Act, the provision was that the political parties should appoint the agent, I think in consortium with the candidate. Now that has been flipped. So it is now the candidates appointing the agents in consultation with their parties. So I think it's important to note that. So don't wait for your political party to appoint agents. The law has now put that primary responsibility on you as a candidate to appoint your agents, but that has to be done in consultation with the parties. So the aim is to give candidates direct oversight over agents' deployments. The polling agents are your primary evidence gatherers, and they have to record 5 critical data points before leaving the polling booths. It's very important. The exact number of accredited voters in the beavers, votes scored by every candidate on the Form EC8A, the number of rejected polls, rejected ballots, figures entered on the EC8A, or a clear photo of the signed form, and then confirmation of whether electronic transmission was completed on sites. And also agents must know their statutory right to request one recount. Under section 60, an agent can request a recount of ballots before the result forms are signed. So the takeaway really from here is that evidence gathering begins with agent selection and training, not when lawyers begin drafting a petition. So the next question is, what should the campaign do when the figures reaching collation do not match the polling unit record? So section 62 of the Electoral Act outlines a step-by-step procedure for resolving disputes during collation. Collation centers typically, if you do election observations, you notice that collation centers are high-pressure environments. Election figures can get tampered with if your agents are passive. So proposed or suggested step-by-step procedure during collation includes, trying to identify or spot discrepancies. I had already talked about mismatch between polling unit results and the ward collation sheets, which is the Form EC8B. That's the next level of results form. And then secondly, it's important to raise immediate objection, register objection before the figure is entered. And it's also important to triangulate your information, your verification, cross-checking the form against the beavers device and then transmitted results on the IREV. And then, of course, it's important to preserve the record, document whether the officer corrected the error or refused the objection. All these things, they may look like a lot of work, but really, when you end up in courts, these can come in very, very handy. They can be very useful to your case. Then section 65 is mentioned here because section 65 deals with the power of INEC to review results. So this already existed before. It was in the 2022 Act. INEC could review results if the declaration was made under duress within 7 days. But now the statutory trigger is now tied to report from INEC officials. So now that's the exercise of this power can only happen if INEC decides. And the power has now been narrowed. It is no longer this power cannot be triggered just because there was non-compliance with, general provisions of the Act. It must be tied to the collation procedure in Section 62. So if there is a discrepancy or if there's a failure to follow that procedure, an INEC official can trigger a review of a declaration of results under Section 65. So Section 65 is not a general appeal against any result a candidate dislikes. So sometimes candidates or their lawyers can send protest letters to INEC, and we've seen that happen to put INEC on notice, but it does not necessarily mean that that's going to be acted upon, and it does not convert Section 65 into a broad administrative appeal or a review of the elections. There's still the court system and the petitions process. So the campaign must use the correct pathway and act immediately. And I think that takes me to the next slide. This distinction leads to a wider point that not every electoral complaint belongs in a single level. So selecting the wrong legal forum for a complaint can cause an otherwise valid claim to be dismissed. This matrix, look at this table on the slide, maps common grievances to their proper legal pathways. So for membership or primary disputes, the proper channel will be a pre-election suit in the Federal High Court within 14 days. False information, false affidavits, again, pre-election challenge under Section 29 of the Act, within 14 days of publication of nominations by INEC. So if there's a polling unit or arithmetic error, that has to be an immediate on-site objection and request for a recount. That's under Section 61. Then for collation mismatch, Section 62 allows for verification requests at the collation center. And there has to be verification and possible recollation, because 62 is also tied to 65. 62 provides that if there's provides for a process for resolving disputes, when collated results are mismatched. Then for duress, false declaration, of course, that has to be a formal petition for INEC review under Section 65. But if the problem or the complaint is a challenge to the election outcome overall, like saying this person should not have been returned, I should have won this election, and the rest of it, and the results have been announced and the declaration made and a winner returned, the proper channel is an election petition by an election petition tribunal. So if we now move to, incidents of bribery, intimidation, falsification, interference with materials, these are electoral offenses and not really results process offenses. This is where the police and legal enforcement comes in, and it should be reported through the appropriate enforcement routes. So this is now a criminal route and is distinct from civil question of whether an election result should be set aside. And I think a lot of times people tend to mix the two. I have seen petitions where they allege, for instance, polling unit error, collation mismatch, and then there are other criminal allegations like bribery, intimidation, ballot box snatching, and the court always separates the two to explain that for election petitions, what we're looking at is whether this return was validly made. But if you have a complaint that, someone carted away a ballot box, they broke someone's head, people were shot, that is a purely criminal matter. And usually it does not necessarily have an effect on the outcome of the result. So there are two pathways for that. That's why you have security at the polling units. So this decision map really is important because a serious complaint can fail when it is taken through the wrong legal pathway. So some of the conduct we have mentioned is not simply irregular, like I mentioned, it may amount to offense. And then moving to electoral offenses, what I have done is to categorize them, just put them in broad categories. Electoral offenses, again, is also a very large portion, excuse me, of the Electoral Act. There are several offenses. So you have campaign offenses, and these campaign offenses, include hate speech violations, inflammatory rhetoric, defacing materials, and, going against the deadline, the 24-hour deadline, or even campaigning before the times open for campaigns. Then you have voting offenses, which includes vote buying, which is a very big issue in Nigeria, impersonation, ballot box snatching. Then, of course, you have the process offenses like nominations, offenses, official collusion, and the rest of it. Then result offenses, falsification of EC8A, false declarations, blocking transmission. So beyond criminal prosecution, these offenses provide factual grounds to challenge compromised results. When violations occur, evidence, is important to lodge, to actually gather evidence, video evidence, and lodge immediate written reports with law enforcement and with INEC. So the final substantive lesson comes from what actually happens when electoral disputes reach the courts. So here, we are now looking at courtroom reality. A lot of election results or outcomes are queried. In Nigeria, politicians don't typically concede defeats. They don't accept that the outcome of elections reflected, the actual voting or the will of the people. So what we have seen over time is that election petitions, the volume of election petitions and pre-election petitions have been increasing. So what I have done with this slide is to just give you a snapshot of a research that we did at PLAC. We reviewed over 1,503 election petitions from the 2023 elections. We had made some very interesting findings. 88.9, that's about 89% of tribunal cases analyzed failed. And that is why, I keep stressing on evidence, having trained polling agents. And then we did a further gender analysis of breakdown, and we found out that there were, out of the 1,403 petitions and appeals that we analyzed, 120 cases involved females. So, which is not surprising given the small percentage of women who participate in elections. And out of that 120, 85% of those cases failed. So women are not just also losing at the ballots during elections. They're also losing in court, and they also find it difficult to defend their mandates. I think it's very important to point it out. So the whole point is kind of just to provide context. And a lot of the reasons why these cases fail include, non-compliance with law, then bringing election pre-election qualification issues to post-election tribunals. I already mentioned that, candidates should be very, very particular. It may be difficult or impossible to flag or to contest a candidate's disqualification once an election happens. That happened a long time. So if you wake up and discover, oh, this person lied on the affidavit, or he said he's this age, and you discover you may not be able, you may be foreclosed legally from bringing it to the tribunal. And unfortunately, this is a very, very huge part of election petitions in Nigeria. So one of the reasons why a lot of petitions failed, again, is because the courts were saying you cannot litigate this issue in a tribunal. You have taken it to the Federal High Court as a pre-election matter. Then, of course, there's the issue of evidence. In fact, most cases fail because of lack of evidence. And the reason I'm presenting these snapshots is to understand why it's important to really, pay attention to these legal positions and make sure you have a solid team that is gathering all these records. So, the percentages are there in terms of the reason why petitions failed. The 74 is a breakdown, the number of tribunal petitions involving women, 45 court of appeal cases, and one Supreme Court case. So the central point is there at the bottom of the slide. Evidence gathering begins at the polling units, not when lawyers begin drafting a petition. So the question then is, what practical systems a serious campaign should put in place before any dispute arises? So I just kind of outlined what I will call a legal readiness essentials. I don't have to ElectHER is going to do a toolkit, or just to wrap up my presentation, I just outlined some of these points that you can note. First is the register verification. I think this just basically summarizes my whole presentation. Verify candidate status in the party member register and preserve relevant records. And then second, obtain party constitution. Make sure you know the provisions, primaries, the guidelines, notices and results documents. Third is the nomination and qualification review before submission. I think we've moved past that because primaries are over now. And I think it's also important to have a statutory electoral, calendar tracker with alerts, to know when there are litigation deadlines. This also is a very serious, even lawyers make mistakes here. They bring applications and complaints before the courts, and then when it's close to the deadline or they're out of time. And then fifth, to create campaign conduct procedure so that messaging, events, spokespersons, and security arrangements have clear approval line. I'm saying this so that, the whole campaign team is on the same page with regards to campaign conduct. Then there's financial login, separating personal fraud from campaign operational accounts, candidate-led agent network, directly recruits, vet, and train polling agents, real-time escalation protocol, establish direct communication channels between polling units, agents, and your legal team, maintaining secure backups from EC8A images and BVAS records, and finally, timely legal advice. Early legal engagement is critical. It's important to retain election law specialists from the onset of your campaign. A lawyer cannot recreate a Form EC8A that was never obtained. Well, they can apply to INEC, but the experience is that it's very difficult to actually get INEC to produce copies during the petitions process. So what you see is a lot of lawyers depending on INEC to give them CTCs. And I'm sure lawyers who are involved in election petition will tell you how frustrating that has been. So the lawyer can't also repair a deadline that was missed if he's not engaged on time or produce a witness who was never identified. So the secure mandate is therefore not only the product of votes, it's also the product of preparation, documentation, discipline, and timely decisions. So I will close by returning to the question with which we began. I had asked a question by asking what must happen for political ambition to become a secure electoral mandate. So the answer is that several things. Several things must go right across your entire journey, party membership from primaries, nomination, qualification, campaign, voting, resource management, and then the timely use of available legal remedies. So I will just close with 4 points or 4 instructions. Number one, know the rules. Understand the Electoral Act, and I'm very happy that ElectHER is doing this masterclass. Also understand relevant portions of the Constitution, the rules of your party, INEC regulations, guidelines, and the timetable that applies to your contests, because there's a different timetable for federal level elections and there's a different timetable for state level elections. Then to protect the process, select and train the people who represent you as a candidate at party processes, polling units, and collation centers. And 3, preserve the evidence to obtain all the necessary forms, record the figures, document objections, identify witnesses, and maintain secure records. And then finally, act on time. In law, we always say something about equity does not aid the indolent. So you cannot sleep on your rights. Electoral rights are among the most deadline-driven rights in our legal system, and the courts are very, very cutthroat with timelines. They don't play about it. You can have a fantastic case, but once you've missed the deadline, that's the end. So a good case brought too late may never be heard on its merits just because you missed the deadline. So in conclusion, legal literacy does not guarantee political victory, and it cannot eliminate every form of manipulation, but it strengthens a candidate's ability, your ability to prevent avoidable mistakes, to recognize a violation, respond to the correct pathway, and defend the lawful mandates. So thank you very much, and I look forward to discussions and questions.
Thank you so much. Thank you for that very insightful, informative, and in-depth conversation, Nkiru. Thank you. Thank you so much to everyone in the group who has also reacted. I saw a lot of reactions. Thank you so much. We already have questions coming in. And please, if you still have questions that you have written down through the conversation, or comments or feedback, just clarification you need, please, you can drop it in the chat box, or you could just raise your hand so that we are able to call you to ask your question. While we do that, I will just go on to ask the first question that we have from Rukaya Husseini, who says, who will be monitoring the candidates' donation fund? There's a second question. Would you want me to read all the questions? We have 3 so far, or just pick them one after the other?
You can read all 3.
Awesome. Okay. So who will be monitoring the candidates' donation fund? That's the first question. The second question is, if there is a result issue, can the results with party or candidate agent be reviewed with the INEC copy? I think that's part of Section 65. Then what problems caused the election to be cancelled or inconclusive? I think that's the example that was given. So those are the first three questions we have right now. Thank you so much.
Okay. In terms of monitoring candidate donation fund, you should have, I mean, it's expected that candidates have campaign teams, right? So if you are getting funding, because you use the word monitoring. So typically when you use the word monitoring, you are talking about like an oversight body and agency. That's INEC's job. So but I'm not sure if that question also implies who will be tracking or keeping records, but it's the campaign team's duty to actually keep those records. It should be INEC performing this function. And there's actually a guideline produced by INEC for political parties on campaign finance and reporting. But the problem is that these provisions are rarely enforced. Like I mentioned, when I was making my presentation, this is where we have a very big gap in our electoral process. Enforcement of campaign rules, enforcement of electoral offences. If there's a results issue, can the result with party candidate agent review and copy? This question, I don't know, it's a bit confusing to me. But yes, the INEC copy, that's the top copy. That is a copy that is used by the commission itself for its own results management. So, but I'm not really sure what you mean is the result issue. It depends where. If the matter is before it's subject to litigation, of course, you can use, in fact, that is what most candidates do. They ask the commission to produce CTCs of their results forms because a lot of polling agents, a lot of candidates don't typically gather their results from. If you are referring to the at the collation, I think those provisions actually refer to INEC. So yes, the way I understand your question, I would say yes. Then what problem caused the election to be cancelled or inconclusive? Again, the question is not very clear to me, but there's something called margin of lead. And I didn't actually address that in my presentation, but there's something called margin of lead or margin of lead principle. So that is where you have an inconclusive election, where there is, should I say, so basically, when the court or before results are declared or when there's a dispute over results, there's this question that they always ask that let me use section 27. I don't know, I'm trying to frame it properly. So if a BVAS is not deployed, the commission is supposed to bring a replacement. And if that replacement is not brought, the result is supposed to be cancelled. If there's violence in the polling unit and repeated violence, the court can record 0. So inconclusive elections is tied to supplementary elections. So there are triggers in the Electoral Act for when certain things happen that can lead to a conclusion, a result being declared inconclusive. Do you understand? So inconclusive elections are connected to supplementary elections. So when the result is now declared inconclusive, then a supplementary elections will be held. The way I like to frame it to say that there are situations where a supplementary elections will be needed, and they are triggered by several provisions in the Act. BVAS deployments, where there's violence in the elections, when all that happens. Because the law typically uses a language, it says if the results be substantially affected, but if it's not be substantially affected, then the INEC can go ahead and declare results from that polling unit.
Thank you so much, Nkiru, for your responses. Rukaya Husseini, please confirm that your questions have been answered adequately, or if you have any more clarifications. Okay, awesome. Thank you so much also. The floor is still open for questions. Please, you can either use the raise your hand icon or just drop your question in the chat box. I can't see any hands up for now. You can also drop your questions in the chat box. While we wait for more questions to come in, just want to inform us that we will be putting up a poll for us. Please respond to the poll. We need to get your feedback on the session so far and how beneficial this session has been and your level of understanding of the session so far. Seeing that we do not have so many questions coming in, please, you can just take a second to respond to the poll while we also still have the floor open for questions. Thank you. Do we have any more questions? Okay, please, if we do not have any more questions, can we, by dropping a comment in the chat box, just say no questions? I feel like it's just Nkiru and myself that have been talking for a while, just so we know that everybody is following the conversation also. You can just type out no questions, all understood, well understood. Thank you so much, Rukaya Husseini. Thank you so much for that. Please, let's get our feedback in the chat box while we also take the poll. Thank you so much, Rashidat Ujo. Thank you so much. Thank you so much for that feedback. Thank you so much. Thank you. Please, if you haven't renamed your device, please do so. I'm not sure who please rename is, but you could just help us change your name so it can help us with collating our attendance correctly. Just rename your device by writing your own name. Please rename. Please, you could just go to your name and write your name properly. Thank you. All right. Please respond to your poll. We have just 4 persons who have responded to our poll. Please, we need everyone. It takes just 1 second. Yes, no, maybe. Just click on it and submit. That's it. Just 4 persons have responded. Thank you so much, Abubakar Mohammed. Thank you. We're still open for questions and feedback. All right, please, let's make sure that we complete our poll and also drop our questions. Our facilitator is very willing to respond to us. Thank you. All right, I will invite our CEO back to the platform to just share with us our next steps and what's required of us after now. Thank you so much. Ibijake, please, you have the floor.
Great. Thank you so much, Nkiru. That was, I learned a lot from that session. This is only the first. We hope to get more people. My charge to women, that are running for elections or aspiring to run for future elections, or, campaign staffers that are on this call is these conversations are really important. They are really important. Understanding how the laws govern you and understanding what to do and how to also, how to conduct yourself as a candidate is really important. The good thing is that I'm sure, Nkiru, we should be able to get the slides to share with the participants, because 1 or 2 of the participants have asked. We're also going to make the recording available on our YouTube page. I'll be sharing that as well, just so that we can have more people access this conversation, because this for me is one of the most critical conversations that we will have, within the series. This is the foundation for every other thing. And I think Nkiru did a fantastic job. Earlier when I introduced you, I'd mentioned that you will do justice, and you did just that. So we're very thankful for that. I think as I also, just run through some of the other topics that we are considering or we are exploring for future sessions. You also see why this conversation as a foundation really matters. And I'm hoping that we can get you, at a later stage when we have more people to be able to share some deeper insight, especially probably around, election litigation and offences, but we can take that offline. So I'm just ambushing you on the call before we ask you formally. So really, thank you so much, and well done to PLAC for all the amazing work that, you're doing as well. Okay, so when I started this conversation, I did mention that this is the first of many, and that the series will be over a couple of weeks. We are hoping that you invite, your colleagues within your network, that you also, invite your friends as well, candidates that are running. If you're looking to support women, even if you're not running, you need to understand the law. You need to know how you can support them, to run very competitive elections. And unfortunately, again, ElectHER, unfortunately, we see a pattern here dating back to 2023. When we invite a lot of female aspirants and candidates to learn more about, this deep insights governing elections, we barely have proper representation. But if we're calling for resources and a couple of things, we'll have the room filled. Let's try to balance this. Let's try to make sure that we are showing up, because we want to show up intelligently. We want to show up informed. The odds are already stacked against women. So it is really important that we understand all these provisions and that we value meritocracy as women. This is really, really important. On that note, I'm just going to run you very quickly through what we have coming up. And this is a draft. The final copy will be published across our platforms next week. Please make sure you share with people so they keep on their calendar. But as we said, we'll also share recordings. But these live sessions are important because you get to ask burning questions. The questions that you have burning, and the questions that you want to ask the facilitator. So we're hoping that when you attend these sessions, you can ask them. Today, we have just finalized session 1. As you can see, session 2, we're talking about the manifesto blueprint. And I will tell you something, we've been working on elections for a while now. 2 things that we've struggled with when it comes to our very lovely primary constituency, the amazing women who run against all odds. 1 is poor visibility. We hardly find information, profiling, digital footprint. And the truth is that if you are not out there, somebody will reshape your story for you. The second thing is we hardly find women with very good, solid manifestos. And that's why we've taken a lot of time to design, these programs to make sure that they really connect to immediate priorities and things that, should help you increase your preparedness. We believe that everyone running as a woman, you're running for the right reasons. You want to shape policies. You want to change the country. And so if you're thinking rightly, if you're thinking to shape policies as a legislator, then it is important that you have a solid manifesto. So as you can see, we have something on manifesto blueprints. Next, we have something around, personal branding and visibility titled Building the Message That Travels Through You. And we're going to be bringing experts to run us through, how to build your visibility, how to harness your digital network, how to grow your presence, how to drive thought leadership, how to build your brand. Because it's so important that as you are campaigning, you are building a brand that stays beyond the campaign season, and everybody wants to get to know you. They want to engage with you. This is very important. We have something on fundraising, helping you understand different ways to fundraise, sharing our story, how we supported women to fundraise in 2023, but also bringing fundraising experts to help you understand how to leverage your network, power of community, digital fundraising, everything. We are not saying that we're giving funds here. It's very important. It is what we're trying to say is that we're also just going to be sharing some practical strategies on how to consider or, leverage the growing digital space to fundraise. And you cannot fundraise without visibility. You cannot fundraise without a message. So as a serious candidate, it is important that you have a message so that people do not think that women are coming, just because they are women. We want women who are sound. We want women who are diligent. We want women who are intellectual. At ElectHER, we don't support women just because you're a woman. We support you because there's absolute meritocracy and because you look like the future of Nigeria that we are trying to really push for. You can also see something around the care conversation. This is very personal to us at ElectHER. In 2023, and we're hoping we bring one of the first time legislators that won a seat at camp. She had run for office for 3 times, and in 2023, when we supported her as part of the wider organization supporting her, because we can't claim that we were responsible for her victory, but again we were able to mobilize support for her, just support her. But she was running with a 9-month-old child then. And I recall as an institution, one of the things we did was to ensure that every time we had engagement, we also made sure that we got a room for a nanny. It might seem very insignificant, but this is what care looks like, community care. So really, it's talking about mental health, talking about how you campaign without losing yourself. And the reason why this session is very important to us is that post-2023 election, we had a retreat for women that ran and lost election. And we remember that it was such a heavy room because a lot of women were dealing with mental health challenges after the campaign. You have a community in us. You have a community within, within organizations that are working in this space. So let us support you. Let us understand your needs. Let's co-design with you. Digital safety for female candidates, then election readiness. In fact, the last 2, election readiness as protecting your vote as a candidate, Nkiru touched a little bit on it. It's so important because what do you do on election day? How do you deploy? How do you watch your vote? What do you look out for? These things are important. And finally, post-election, it is really about election litigation and offences. Now, for section 6 and 7, we might be moving them upwards because we believe that these are really important in communication or information that every candidate should have. So as we said, we're still finalizing this list, and by next week we should have the full list of all the sessions that we're going to be implementing published. The final thing I would share in terms of what is coming is that we now have our Decide to Run toolkit, and we'll also be sharing that for the first time with everyone that attended this session, and you can send to your network as well. It's a very thorough document and it becomes your playbook. So anytime you feel stuck, excuse me please, anytime you need extra information, anytime you want to understand the landscape better and then just be able to brush up your skills, the Decide to Run toolkit will be there to support you. So we're going to be sharing this toolkit. It's a really comprehensive document. But we're really glad that it also aligns with a lot of the things that Nkiru shared today. So please expect this, from us in the new week. We'll be sharing that with you as well. Thank you again for joining us. I think right now I'm then going to hand over back to Nkiru. I'm also going to be sharing the second polls. We please ask you to support us in filling these polls. These are very important. Because when we do not get feedback, then we do not. It doesn't send a good signal to us that we've been able to impact you. But again, remember, we're supposed to co-design with you so that where things are not clear, where you feel that we can do better, we also understand better. So we encourage you to please answer the polls, and we look forward to seeing you next session again. I'm going to hand over back to Zugwai, to then close and facilitate, I think, group photographs. Thank you very much, everyone. Bye-bye.
Thank you so much. Thank you, ElectHER, for that very detailed next step conversation. Thank you, everybody, for taking the poll. I can see more persons have taken the poll. We will be resharing both polls, the first and the second. Please make sure you take it. I know that I received a question about not receiving the poll. So we're not sharing the poll maybe in the chat. It's actually on your screen. So you would see a question on your screen with yes, no, and maybe options. And so you could just click on that, click on the right response for you. That's the poll we're asking for. Thank you so much. Please, one more ask from you, if you can, and if you're in a place where you can put on your camera, please help us put on your camera so that we could just take a group photograph. Thank you so much. This is also part of networking. We just started networking as candidates and aspirants. So please just put on your camera so that we're able to have a good view. Thank you so much. Okay, please confirm if you can see everybody clearly to take a proper picture. And let's know when you're done. Thank you so much, Ibijoke, for that smile. Please, everybody can also smile. Thank you, thank you, thank you very much. Thank you. All right, thank you so much. Oh, okay, more people, more people. Thank you, Asmao. Thank you, everyone. Oh, more people. So I think we'll just wait 1 more minute because I feel like people are still adjusting to take pictures. Thank you so much. All right, thank you again. Please, before we go, I still see that some people have their names as Ibijoke. Thank God for the camera that we put on, so I could see that. Please, you can just quickly rename your device. Go to participants just below your Zoom screen, click on it, and check for the first name on the list. Thank you, Rukaya. Check for the first name on the list. In brackets, the name that has me in brackets, just rename it to your own name. I can also see please rename. You still have your name as please rename. Please help us rename. Just click on participants where you can see the number of persons. Click on participants. Go to the list. There is a name that has me in brackets. Just edit that name to your own name. Thank you so much. Thank you, Honorable Vera. Now I can see your name. You have your hands raised. Please, you can unmute. Honorable, thank you.
Yeah. Good evening, everybody. Thank you so much. The lecture was very impactful. I think I've learned one or two from today's lecture, which I'm very, very grateful. I want to say a very big thank you. At least coming today for today's meeting is a plus to my political career, which I'm very, very grateful. I want to say a very big thank you. Thank you so much. Thanks.
Thank you so much. That means a lot. So that's a very good feedback we're going to run with, meaning that please, you would help spread the news also to other participants, other candidates and aspirants that you know of who are running for office and would love to be a part of this conversation. The next proposed date for this second session is the 7th of August. Please tell more persons to join. We'll put out the registration soon, and hopefully we're able to get everybody within your network who are running for office to be able to get more support as you have gotten also. Thank you so much once again, Nkiru, for your time. Thank you for sharing your depth of knowledge.
Thank you for having me.
Questions. Thank you. Thank you, everyone, for coming once again. And we look forward to going on this journey with you right through till the end. Please don't get tired. We are hoping that you'll be a part of us on the 7th and you will come along with more persons so that at the end of the day, we can truly say that we are going out ready and prepared for our roles. Thank you so much and see you soon.